So welcome everyone to another Get Legit webinar. This is, let me start just realized I want to share my screen and show you guys. Sorry, I started this a little early. Okay, here we are. Everyone can see that, right? Perfect. This is cannabis rescheduling to Schedule 3 and what it means with NORML's legal director, Bill Panzer. Today is Thursday, June 4th, 2026, and my name is Erin. I am the Education and Communications Manager here at the Cannabis Alliance. I would like to thank you all for joining us this afternoon. It is our hope that anyone interested in commercial cannabis here in Nevada County will take the time to tune into these webinars, educate themselves, and continue to be or become stewards of the environment and of our community. The Get Legit educational series provides the preparation necessary to assist in securing a local cultivation permit and state cultivation license. The series includes webinars, support groups, business skill training, and a mentor program. All of these webinars are online, free of charge, and they are open to the public. So what is the Alliance? We are a nonprofit trade association representing the local cannabis industry here in Nevada County. Our mission is to support public policy initiatives through representative advocacy and provide educational opportunities for business growth and success. There are lots of ways to get involved with the Alliance, and one of those ways is to become a member. The Nevada County Cannabis Alliance plays a vital role in shaping policies that strengthen the economic sustainability and success of our locally licensed cannabis industry. If you are a licensed cannabis business in Nevada County that has benefited from the policies we've helped advance, we warmly invite you to join our membership so we can continue supporting and advocating for our local cannabis community. We truly appreciate your partnership and support. Some services that we provide are a consistent voice and representation locally and at the statewide level. Year-round continuing education that includes compliance and regulatory workshops, business training skills, and cannabis farming best practice seminars, and more. We help you navigate the permit and ongoing compliance processes with the resources and support you need. We have a buddy program that pairs new cannabis applicants with licensed farmers who are seeking support with permitting, regulatory compliance, and implementing best practices. We also have seasonal industry mixers and events for community and connection. Another way you can get involved is to become a sponsor. If you are a local business that values a strong and thriving cannabis industry here in Nevada County, we invite you to partner with us as a sponsor. Your support directly strengthens our advocacy, policy work, and community engagement efforts. We're deeply grateful to the sponsors who stand behind this work. Your investment makes everything we do possible. I want to give a shout out to a few of our allied industry business sponsors, CCOF, or the California Certified Organic Farmers Organization, Ag Natural, Cramner Engineering, Plan Air Landscape Architecture, Humboldt Seed Company, Mr. B's Green Trees, Gold Coast Botanicals Farm Labor, Elevation 2477. Thank you all so much for your support. If you are interested in becoming a sponsor, you can email us at info@nccannabisalliance.org, or you can visit our website, which is nccannabisalliance.org/sponsorship. Other ways you can get involved are to follow us on Facebook at facebook.com/Nevada County Alliance and Instagram at Nevada County Alliance. You can subscribe to our newsletter just by going to our website at nccannabisalliance.org/subscribe. And if you have any questions, you can just email us at info@nccannabisalliance.org. I know that's a lot of links. I'm going to put those in the chat for you to reference and click on as we go through the presentation. At the moment, we don't have any upcoming webinars, but you can find all of our Get Legit webinar recordings and links to register to upcoming events at nccannabisalliance.org/getlegit. We also have a YouTube channel that has all of our previous recordings, and the link is too long to read out loud, but I'll put it in the chat. And you can refer to older webinars. Some upcoming events. So we are celebrating 10 years with the Cannabis Alliance. It's our 10th year anniversary party. Join the Nevada County Cannabis Alliance, celebrating 10 years of advocacy, collaboration, and community. This event is for members, supporters, and friends of the Alliance, and the date is August 18th at 6 p.m. You can visit nccannabisalliance.org/events for more information about that. Okay, so to wrap things up on my end, the format of today's webinar is that Bill will give a presentation with a Q&A to follow if you have questions. Your participation is encouraged. We have a chat section and a Q&A for you to use that we will be monitoring. And feel free to ask any questions that you have, as that will make this webinar more useful for everyone. This webinar is being recorded and will be available on our website, again, at nccannabisalliance.org/getlegit. And that is it for me. Diana, do you have anything to add?
Hi, everyone. Diana Gamzon here, Executive Director of the Nevada County Cannabis Alliance. And I am very excited for today's webinar and to welcome Bill Panzer, Legal Director of NORML, to today's conversation. Bill is a longtime cannabis attorney based here in Grass Valley, with decades of experience protecting the rights of cannabis patients, producers, and consumers throughout California. His legal practice has focused on cannabis law, criminal defense, expungement, and all other areas of the cannabis industry, and has been deeply involved in cannabis policy reform for many years. Today, we're especially grateful to have Bill join us to help us unpack what federal cannabis rescheduling could mean for cannabis, for California's small cannabis operators, what opportunities it may create, what risks are there, what small businesses should be paying attention to as the legal landscape continues to unfold. I will also mention that Bill is a recent KVMR broadcaster with Red Eye Radio. Just had his show last Friday night, which is weed-inspired music. And so tune into that in the archives. And so happy to have you with us, Bill, both here locally as well as joining us on our webinar now. So I'll hand it off to you. Thank you.
All right. Well, thank you, Diana. That's quite an introduction. I will say that I probably have a lot more questions than answers. Going back to kind of the history of how we got to where we are now, this kind of started back in 2022 when Joe Biden asked the Department of Health and Human Services and DEA to look at rescheduling cannabis. They looked at it in 2023. HHS recommended rescheduling, said that to DEA. DEA looked at it. In 2024, they suggested rescheduling to Schedule 3. Then nothing happened until Trump recently did sign the executive order, which brings us to now. People don't quite understand what's in an executive order. It just says something should happen. It doesn't make them happen. In this case, the executive order looked at two areas. One, it said that the AG should go ahead with the rulemaking process to put cannabis in Schedule 3. And two, it also directed White House to work with Congress to update statutory definitions of hemp-derived cannabis products. One of the issues that's come up now is under some new legislation, hemp-derived cannabis, like CBD, with even trace amounts of THC, may no longer be legal under federal law. So the executive order said, Congress, let's talk and see how we can fix that. All right, so that would allow, in Schedule 3, there's two basic things that change right away. One, it makes it much easier to do federal research on cannabis. Prior to this, if you wanted to do federal research on cannabis, you were required to apply to the federal government, get permission, and then your cannabis came from the government's cannabis farm in Oxford, Mississippi, at the University of Mississippi. I don't know if it's still run by Dr. El Soleil or not, but he ran it for years. The few people remaining on the federal program that gives medical cannabis to patients, there were up to 7 at one point, their cannabis came from the Mississippi farm. And I will tell you from personal experience, it was not very good. And so scientists were blocked out from doing the research, or they were limited to very limited permissions were given out, and they were limited to using the cannabis from the Mississippi farm. Putting it in Schedule 3 will make research much easier to do. And I think that's very important. Most people don't really look at that part of it, but I think that's a very important part. It will also, once things get worked out, it will most likely alleviate the 280E issue. For those not aware, under the IRS Code Section 280E, if you're engaged in an illegal industry, selling illegal drugs, Schedule 1 drugs, narcotics, you're not allowed to deduct your business expenses from your taxes. So essentially, people in the cannabis business, even legal and state law, were paying taxes on their gross, not their net. And that was very difficult for a lot of people. A lot of people could not function in the industry because of the 280E rule. Once in Schedule 3, and then people can distribute it lawfully and have a lawful business or cultivate it lawfully, when we get to that point, then the 280E goes out the window, and you can go ahead and deduct your regular business expenses, your rent, your fertilizer, your packaging, all of those things that you can't deduct now. So the order is limited to marijuana-based products that have already been approved by the Food and Drug Administration, and that's things like Marinol, Epidiolex, I think it's called. There's a couple of other Marinol-like substances. And it also applies to cannabis that's handled within state-regulated medical marijuana programs. In other words, what their initial thought is, if the states are handling it well enough, we can rely on the states to control it. Now, what do the states have to do to qualify for handling it well enough? Who knows? That's going to be decided at some point. In April, toward the end of April, the DEA announced that they had issued an order immediately placing medical cannabis in Schedule 3. But that doesn't put adult use cannabis, or what's commonly called recreational cannabis, in Schedule 3 the same. How they're going to differentiate which cannabis is in Schedule 3 and which cannabis is in Schedule 1 remains to be seen. I'm not aware of any controlled substance that has a similar situation as that. The real answers are not going to come until the end of this month. On June 29th, right now, there's a meeting scheduled with DEA and FDA and all the actors to try and figure out how to implement this new rescheduling. There's a lot of concerns from different areas. There are people that want more liberal rules. There's a lot of Republicans that don't even like this, that want to squeeze it back in Schedule 1 if they can. So really what comes out of that meeting is going to be very important, and that's when a lot of the questions are going to get answered. There's a few things that have come up that we can answer, sort of answer. A lot of people ask, what about the Single Convention Treaty? For years and years and years, we've heard, well, the federal government couldn't legalize cannabis anyway because of the International Single Convention Treaty. I always took those arguments with a huge grain of salt. I mean, all we have to do is look at the history of this country and how the Native Americans were treated to see how well the government relies on treaties and follows treaties. Now that they're talking about rescheduling, when the issue has come up, they're now saying, well, they think they figured out a way that they can do this and not violate the Single Convention Treaty. The one part that I don't see them in all what they've published that would get around is the international trade. Single Convention Treaty bars international trade in cannabis. And with the proposed Schedule 3 transition, would do nothing to change that. So I think as far as the Single Convention Treaty goes, we could bar international trade for now. But other than that, I think the government treats it like any other treaty. If they like it, if it helps them, they support it. If it doesn't help them, we can overlook it. And that's kind of what's going to be going on. Another question that comes up, of course, is the medical versus adult use, because it's very clear that this affects medical use but not adult use. Here in California, most of the licenses are for adult use, so this isn't going to help anyone that just has an adult use, that's selling adult use. Now, we have adult and medical licensing, it all as part of one license. You can get both of those in California. DCC, as I understand it, is now looking into providing separate licenses for medical and adult use. Now, how that's going to play out if you have a dispensary that sells both medical and adult use, I have no idea. And I don't think DCC or DEA has an idea yet either. That's something that's going to have to be worked out. Also, key implication for employers. They're going to have to look at ADA accommodation requests for medical cannabis. Employers are now going to have to consider to allow their employees to use cannabis for medical purposes now that it's Schedule 3. And they may have to make accommodations. They may have to put in a smoking area or make some other accommodations for patients that need their medical cannabis. And let's see what else we got here. Okay. Yeah, that's kind of about it, actually. I mean, we don't really know what's going to happen. The June 29th meeting is what's going to be really important. That's where they're going to start getting down in the nitty-gritty, and we're going to see how this is going to play out. Are dispensaries going to have to do medical only and stop doing adult use? I mean, I have seen some edicts come out from the DEA that say that someone who's been involved in illegal sales of narcotics will not qualify for a license. Now, how that works with someone that is legally under state law distributing both adult use and for medical use, it remains to be seen. I wish I could give you more definitive answers on this, but they're really not there. It is a great step in the right direction, and I think it's going to very quickly provide 280E relief, at least within the medical cannabis area. Again, how that translates to people that sell both or cultivate both, I don't have a clue. Other than that, I mean, it's just a discussion. You know, if you have any questions or comments, I mean, again, I wish I could give you more information, but it's all up in the air right now.
Thanks so much, Bill. And there's actually a Cannabis Advisory Committee discussion this morning with the Department of Cannabis Control. If anybody was on that call, who's on the webinar right now, and what you're reflecting is actually very similar to what Director Clint Callum reflected in this morning's discussion, that we just have so many unknowns. And one of the things that Director Callum expressed from the DCC is that even the DCC has not had engagement with the DEA on this, despite a lot of effort. In fact, Director Callum mentioned that no state agency across the country has had engagement with the DEA since this rescheduling came out, and as we all prepare for this hearing. So there's so many unknowns. But just to kick off some hypotheticals and kick off the discussion, we encourage people to ask questions and put questions in the chat. But hypothetically, and based on what you've read, could rescheduling move cannabis towards a more pharmaceutical or corporate model? I'm based on the language around medical and some of the language that you've read. Could you express any thoughts you may have on that?
Well, it's going to have to, because any other Schedule 3 medication, you have to go to a doctor. You have to get a DEA-approved prescription. You have to go to a pharmacy. It has to be distributed by a pharmacist. Here, we don't have prescriptions, so a lot of people call them scripts. Actually, under the law since 1996 in Prop 215, what we have are physician recommendations or approvals. Back when we were drafting 215, we were thinking about the area of prescription and the fact that the federal government could make a pretty good argument that the feds had preempted the area of prescription, and a state could not set rules that were different than what the federal government did. Well, prescription is two things. It's direction to you from your physician of what you should be doing, what you should be taking medically, and it's instructions to the pharmacist behind the counter at Rite Aid of what to put in the bottle to give to you. When we were drafting 215, we knew that no one was going to Rite Aid to get their cannabis, so we didn't need that part of it. And so we made it recommend or approve to avoid the federal preemption issue. So now that and then other states have followed that. All other states, it's basically physician recommendation or approval. It's not a DEA script pad. And so you're either going to have to change it to, you have to have a script pad, you have to be a physician using a DEA authorized prescription, or they're going to have a new definition for getting access to Schedule 3 medications to allow for the recommendation or approval. Similarly, they're going to have to change the rules for distribution, or they could just say you have to have a pharmacist in your dispensary, which would basically make it meaningless. I don't know many dispensary people that can afford to pay a pharmacist to hand out the medicine. So that's another area that's going to be very interesting to see what they do, but that is a problem.
Thank you for that. There was a comment in the chat about Nevada County can only have medical licenses. Nevada County actually allows for both medical and adult use cultivation, though our ordinance did start out as medical only, but just for just responding to that direct question, with the ordinance updates a couple years ago, one can get either a medical or adult use. Just clarifying out there. Another question that I have for you, Bill, and actually I want to add on to that. We do know that the Department of Cannabis Control is developing regulations at a statewide level so that if a cultivator had an adult use license, that there would be a simple way to change that to medical. So they are working on that. But just putting that out there for the commenter. Another question that I do have is that, knowing that our farmers here in Nevada County, we are small farmers, we're trying to figure it all out. We're working on, of course, shoestring budgets and just trying to navigate this landscape. Is there any unofficial, non-legal, of course, advice that you may give to some of our small operators as they try to navigate this, especially in the next couple of weeks when the window to register with the DEA closes? I mean, how should we best navigate this as small farmers and small businesses, small cannabis businesses?
I think you have to take a wait and see attitude. Certainly, look at the news, see what happened at the hearing on June 29th. And I think that hopefully will provide direction of how people in the industry can proceed. But as of right now, it's a crapshoot.
Yeah. And then, what about issues related to, you've spent your career working on cannabis, going back to some historic times with our industry, and how can uh, rescheduling help in terms of destigmatizing and reducing potential risk as it relates to banks, insurers, landlords, community members? I mean, how can this be part of an advocacy conversation?
It makes people feel a little more comfortable. I'll give you an example. I'm wrapping up a settlement right now in a case between two people who were supposedly partners in a cannabis venture. And part of the settlement is my client is transferring the deed to a particular piece of property to the plaintiff. And part of the settlement also is that my client's going to transfer his right to apply for a permit to the plaintiff. When we went to the title company to arrange for the transfer of the title, they backed off and they freaked out because they saw the part about the cannabis permit and they didn't want anything to do with any cannabis statement at all. And then while we were discussing this, this all hit the news, and all of a sudden they became much more comfortable with going ahead and helping with the transfer of the property, and in spite of the cannabis part to it. So, any time that, people who are worried about this see it on the news, see things about rescheduling, everything like that, it does make them feel a little more comfortable about it.
Yeah, I definitely agree with that. Question that we have from the chat is, what about indigenous groups? It seems like they've been left out of the conversation entirely. And then there's a follow-up to that, but we'll start with the indigenous groups.
I really can't say much more than there's nothing that I've seen in anything I've read about this that would address that. I don't know that it's really that big an issue. I mean, certainly, indigenous people can get medicine. They can go to the pharmacy, they can buy medicine, they get prescriptions, etc. I don't see that really changing. A lot of the issues in California have come up with that I've seen have been with cultivation and cultivating on tribal lands, and to what extent that violates state law or not. But as far as rescheduling, I don't see where that's that much different than just for non-indigenous people. But I'm certainly not a Native American expert.
Got it. Thank you. And another comment from the chat is um, regarding the 60-day window, there's an understanding that it is an expedited window, but nothing that says that we cannot apply after the 26th deadline. Is that correct? Or does the window close on the 26th?
Who knows? Honestly, I really think that's going to be addressed at the meeting on the 29th. They're going to have to discuss, who gets licenses, can you have a license? If you're distributing for adult use, can you still get the DEA license? And in fact, I believe that to apply for that now in that 60-day window, they did say that you cannot be distributing any other narcotics or anything that was illegal. So, I really think whatever they're talking about now is not going to be the final solution. The final will come out of that June 29th meeting and whatever follows up that.
Thank you, Bill. And do you believe DEA registrants will be limited to conducting transactions only with fellow registrants, period? Or will they only be limited to conducting transactions for medical cannabis with fellow registrants, which is assumed?
I don't have a clue. Again, there have been rules in place for years and years and years about how to deal with Schedule III controlled substances, who can produce them, who can distribute them, who can distribute retail, who can all of that. None of that's going to apply to medical cannabis.
Mm-hmm.
We're not going to have Eli Lilly producing it. We're not going to have Rite Aid with the pharmacist distributing it to the patient. None of that. They're going to have to come up with new rules.
Mm-hmm.
And so far, everything I've heard has just been suggestions.
Yeah. Has anything like this happened in history that we can reflect back on? I mean, a rescheduling, or I don't know. I mean, just is there any other type of crop or product that this is where this has happened? I don't think so, but I'm just asking the question.
Not that I'm aware of. I mean, we did have the rescheduling of Marinol, for instance. When Marinol came out, they had to schedule that in Schedule III, but that was, again, a substance that was being produced by a drug company and was being sold through Rite Aid or Long's, whatever, at the counter by a pharmacist. Yeah, this is new. I mean, this is unprecedented, and it's going to be very interesting to follow over the next few months.
Mm-hmm. What types of policies or, whether it's legislation or regulatory changes, do you think would be necessary, or that organizations like ourselves, like the Nevada County Cannabis Alliance, or independent operators should be advocating for to be able to stay nimble, to be able to stay ahead of the curve? Today on the CAC meeting discussion, that the comment I made during that meeting was just about, we have no control about what's going to happen federally, and we are all kind of walking around with blindfolds on trying to figure out what this is going to look like. But what we do have control of is here in the state of California. And so my question is what types of policies or shifts should we be looking into as advocates or small operators to be able to stay nimble, to be able to access consumers, to be able to, at least in our bubble of the state of California, have control over our businesses to be able to be successful?
Good question. I personally think it should be descheduled, but that's not going to happen. But certainly now that it's being rescheduled and kind of coming up more in fresh air and fresh sunlight and more acceptable, there might be a time to start putting pressure on your local representatives to relax some of these ridiculous rules that we have in California. I mean, it's highly over-regulated. The track and trace is ridiculous. I mean, that would be like telling the wine industry that we want to be able to walk in a restaurant and point at a glass of wine on someone's table, and we want to know the exact grapevine that the grapes in that particular glass came from. Imagine what that would do to the price of wine. I mean, the pricing in California has very, very little to do with cost of manufacture. It's because it's overregulated, overtaxed, and I think that's something constructively that can be done. It really needs, the regulations need to be relaxed. This is not plutonium laced with arsenic. Cannabis is not that dangerous. Certainly, it shouldn't be any more, regulated than wine or tobacco or something like that, which are worse. So, for that sense, I think putting pressure on your local legislators and state legislators to relook at the cannabis rules and relax them some, I think makes sense.
Thank you. Another question from the chat is, will Schedule 3 allow licenses in California, specifically cultivators or distributors, to ship internationally to other legal countries? And just for some background on this, we understand that potentially there might be experiences where that may already be happening, but what do you know about international shipments?
Well, it's banned by the Single Convention Treaty. I'm not aware of anyone legally selling cannabis out of the country. I'm not aware of anyone legally selling cannabis out of the state. I think that we'll see relaxation in the, within the country and distribution within the nation. But I think we're a long way off from international distribution. That's going to have to take not only change in the rules in the United States, but change in the rules in other countries too.
Thank you. Any other questions that people may have? Feel free to put them in the chat or the Q&A. We did have a comment. Bill Panzer's a legend, and thank you for joining us. So that was we've got some fans in the crowd. He's also a rock star, I've learned.
Yeah, that and $7.50 gets me over the Bay Bridge.
Exactly. So some other questions that we have is what should or if there's any practical advice related to 280E or things that people can be doing now to prepare for that. That seems to be the one tangible item that all of us small operators can at least hold on to as a bright spot with all of this unknown that we do have in the world of rescheduling. But can you just dive a little deeper into 280E and how it could impact some small cannabis businesses and what we should be doing to prepare our businesses?
Well, if 280E doesn't apply to at least medical cannabis sales anymore, that certainly is extremely helpful for everyone in the industry because then you get to deduct your actual business expenses. Right now, if you're running a dispensary, the only thing you can legally deduct is cost of goods sold, which are actually paying for the cannabis that you're distributing. And that was hard fought to even win that exception. Anticipating that 280E is going to be not applied to in some manner to cannabis sales. There's going to be some way to do it where you're not under 280E. I mean, all you can do really is keep track of what's going on, keep your ear to the rail and figure it out. And also I might think about doing my books two different ways, doing it like I'm doing now, but also keeping track of my costs as if there was no 280E. And so that you're ready that when you're in a position where you can opt out of the 280E restrictions, you're ready to go. You've got all your numbers ready. You've got, your accounting ready. And you can, another question that comes to mind too is whether there's going to, and this is just something I just thought of, whether there's going to be any reparations, whether people are going to be allowed to apply for some kind of refund. from taxes that they were overtaxed on in the past. Now, again, that's just something I just thought of, but it's something I would consider if I had a dispensary.
Thanks for that, Bill. That's very helpful. And okay, on that note, will there be a possibility to refile taxes for prior years? So it looks like you've that thank you, Elise, for that. You were both thinking the same thing. Yeah, will there be a possibility to refile taxes for prior years, 2018 to current? That was the question.
Who knows? But again, I'd be ready to jump on it and do it if it comes to fruition.
Other questions that people have, now that we have Bill here, we are having
I also want to mention that if you have a question and you're not sure exactly how to maybe put it into, the text or the chat or the Q&A, you feel like you need to talk it out. You can raise your hand and you can speak your question, and we can allow that function to happen. So just let us know. Raise your hand in the chats in the bottom of your bar in the Zoom. It says raise hand.
Uh, in preparation, Bill, for the hearing on June 29th, as small operators here in California, how can we, as both associations, but also as small operators, most effectively participate in those discussions at a federal level, from an educational point of view, or, through your work as an advocate over many decades, enlighten us onto what you advise and how we can best support our farmers and small businesses here in California.
Well, I don't know if they're accepting any submissions. That's something you could go online and find out pretty easily. Um, if they are, as an organization, you can certainly put in a well-drafted letter explaining your position. That can't hurt. Um, the other thing is, I don't know if the hearings are going to be on C-SPAN or carried somewhere. I think there's going to be a lot of interest in it. So it wouldn't surprise me if these come up on C-SPAN. If they do, you can watch it.
Thank you. Another question that has come up is any idea how TSA will handle cannabis? I've never had a problem flying within California, but what about consumers flying from, say, California to Idaho or other states?
Well, I think there's going to be a big difference between medical and adult use. Certainly, if you're traveling with your cannabis and you have a physician's recommendation, you should carry it with you. Also, the amount that you're carrying, I think, is relevant. If TSA stops you and you got 3 kilos and you say, well, I'm a patient, I'm going to New York for a weekend, and that's not going to work. But from what I've seen, TSA, they're not really looking for cannabis these days. They're much more interested in bombs and things like that. But, it's always tricky. So I always say, check the laws of where you're leaving, check the laws of where you're flying to, and make sure, if there's like an ounce limit or something, make sure that you're under that limit. And again, carry your doctor's recommendation or approval with you.
Thank you. All right. What other questions do people have as we all navigate this unknown together? I'll give it a moment to see what questions we have for our discussion.
I have a question. So this is, being passed federally. Will that still give states the right and opportunity to make, keep cannabis where it is? Like, can they kind of opt in or out, or is this like across the board?
Well, if it's Schedule 3, that's federally. That means that, for instance, the laws that would say that it's illegal to possess Schedule 1 would no longer apply if you're possessing it at Schedule 3 for medical purposes. So, that would be a change. States can't opt out. States can't say, well, we don't recognize that the feds put it in Schedule 3. Now, they can certainly pass their own laws. But if they were to, let's say California says, we're going to put cannabis in Schedule 1 in California under the state scheduling, I think there'd be a good argument to go into court and say that the state doesn't have the authority to do that that the federal government has preempted the area. They've taken over the area of scheduling controlled substances. And when a federal government has taken over an area completely, that preempts the states from acting in that area. I mean, that was the issue we had with Prop 215, as I said before, in that we felt that if we put the word prescription in there, they could come in and say that, the federal government has preempted the area of prescription. And that's why we left that word out.
Okay. Interesting. Thank you for that.
With cannabis becoming a Schedule 3, what do you know about the federal rulemaking process? So new federal regulations, record keeping, compliance requirements. People are being asked to register by a certain date, but it feels unknown in terms of what these regulations are going to be and how they will roll out. And so from your experience, what does the federal rulemaking process look like in terms of timelines and things like that?
Slow.
Yes.
Very slow. And very, maybe I'm a cynic, but I think it's very result oriented. They start out going, we don't want to reschedule cannabis. So they go through the actions of it and they pretend that they're looking at it. And then they come out and they say, no, that's what they've always done. Some of these petitions to reschedule have sat there for like 7 or 8 years, I believe, some of them, even if not longer. And NORML did one about 30, 40 years ago that took years and years and years before it was denied. So, the feds do what they want to do.
Mm-hmm.
If they want to go fast in this, they'll go fast. They want to go slow, they'll go slow. I think a lot of this is distraction. We're talking about cannabis. We're not talking about the Epstein files. We're not talking about the $1.8 billion slush fund. We're not talking about all kinds of, what's going on these days. So to that extent, I think that cannabis is a distraction for this administration. And it's also a way to appeal to younger people.
Mm-hmm. As we anticipate in a slow process, regulations coming out at a federal level and just navigating this landscape, what protections hypothetically do you think would need to be in place for small operators to make sure that our small businesses are not left behind at a federal level?
I don't know what you can do. Basically, keep track, see what what rules they put in, and then try and abide by those rules. That's about all you can do. And it's very difficult to do when we don't have a clue what those rules are going to be.
Mm-hmm. Mm-hmm. I know there's questions that have come up around taxes and things like that. Another question that just came up, was there any benefit in California switching to adult use over medical? I've already had my license designation switched at the DCC, and my license now reads medical and adult, but I'm still wholesaling the exact same product. Could a lot of this uncertainty be mitigated by reverting all licenses to medical?
Well, sure. I mean, if the federal government's going to say that it's Schedule 3 for medical purposes, and the state decides that they're only going to allow medical use, yeah, that would make it easier to comply. I don't see that happening. I don't see the state taking a step back. And, I don't, for one thing, Prop 64 was an initiative. And when an initiative passes in California, the legislature has no authority to repeal it unless the initiative gives them that authority. And Prop 64 gave the legislature authority to amend it or change it to make it better for the purposes of making adult use even more acceptable or more available. The legislature could not legally repeal Prop 64. So I don't see the state going back to only medical. But depending on how the federal government regulates this, it could be that only pure medical dispensaries or pure medical cultivators would comply with federal law. And what they would do with people who are not complying with that, we don't know. They might shut down your dispensary if you're doing both. I think that's the idea behind DCC's looking at now taking the joint licenses and splitting them into 2 separate licenses.
And that question was also raised on the Cannabis Advisory Committee call this morning, and Director Clint Callum basically reiterated, very similar to what you just expressed, Bill, is that because of Prop 64, there's limitations. But beyond that, it would be impossible because it would mean that the DCC would be taking a stance that all cannabis is medical now, and that's an area that they're not willing to kind of go down because of legal reasons, but also just taking a stance on medical only and not, stating medical benefits. And so, yeah, it seems like there's a lot of creative options that people were thrown out. It was a really nice discussion this morning. But yeah, it does not seem like that is going to be an option. Other questions people may have?
It brings back, remember that Dennis Perone used to always say, all use is medical.
Yes,
That
exactly.
even people who think they're using it recreationally are actually using it medically.
Exactly.
And maybe that's what we need to do.
100%. And I was really grateful for the commenters this morning on the call who reiterated that stance. And I know that many of us on this call also support that. All right. All right. Other questions that people may have, since we have Bill on the line and you have just such great experience with 215. Did you ever think, with being there when 215 was being written and seeing that roll out? I mean, what did your crystal ball predict? There is no crystal ball with cannabis, but how has your experience been watching this industry unfold since the 215 days in the 90s?
I was just talking about that with my wife. Excuse me. We went up, I think it was on April 18th, Saturday before 420. The local dispensary here in Grass Valley had a little party out in the parking lot. And my friend's band was playing there. So, between those, we went up and hung out for a while. And then I went inside the dispensary. I'd never been in there before. And I was just standing there looking at this. It was like being in the Apple store or something. My wife and I were just laughing about, we never thought we'd get to this point. I grew up in the days where, I was buying my weed from some guy that hung out at the college, and, things have certainly changed. But then again, it's been 30 years since Prop 215. So 30 years, things happen.
Mm-hmm. Yeah, an interesting perspective that you have on it all, especially being so tied in with policy, and so you do have a unique perspective on it. Do you think it's fair to assume we will have to pay double the licensing fee and the city fees, et cetera? It would completely kill mom and pop shops if that were the case.
Again, who knows? Unfortunately, I think California has kind of turned their back on the mom and pop shops. I know when Prop 64 was on the ballot, and they talked about protecting the small growers and protecting these small, operations, but it didn't seem to happen. Money talks, and the people with big money were able to get things pushed their way. It's as far as licensing, increasing it. Who knows? Again, I'd be guessing.
Yeah. Was there discussion after 215, maybe like years later, or however much in the future, but was there a discussion about reforming 215 amongst the core group and advocates that put 215 together in terms of next steps of policy between that and when McCursa came out? I mean, just your involvement with the policy discussions historically, how that all played out.
Yeah, 215 started out. Dennis Perone decided that we weren't going to collect money, we weren't going to pay for signatures, we were going to get the signatures with love. And he believed that all he had to do was get everyone in San Francisco, every registered voter in San Francisco, to sign a petition, and that would be enough signatures. That probably would have been, but none of that happened. we got to the point where it looked like we weren't going to get enough signatures, and that's when George Soros's people came in, Drug Policy Alliance. I think back then they were still called Linda Smith Center,
Mhm.
and they basically financed the camp getting signatures to put 215 on the ballot, and they financed the campaign. Now, their belief was that state medical cannabis initiatives can't do anything other than put pressure on the federal government. They're not good for anything other than putting pressure on the federal government. And for example, they were quite upset when they got into it to discover that 215 did not give the legislature authority to repeal it or amend it. They would have liked that. Also, they were very upset that it had cultivation. They had done polling, and their polling showed that without cultivation, it had a better chance of passing than with cultivation. And again, they didn't believe that it could do anything other than put pressure on the federal government. So they didn't care if it had cultivation in it or not. I think looking back, it would have been a whole different ballgame if it did not have cultivation in it. It would have been nearly what it was. And as far as letting the legislature amend it, people forget. I mean, 215 is often called the first medical cannabis law in the United States. It was actually one of the first two. In that same election, November of 1996, the state of Arizona also passed a medical cannabis initiative. But in Arizona, their legislature had the authority to repeal it, which they immediately did. Uh, then, as we went on, the people who put up the money, the George Soros people, Drug Policy Alliance, etc., their belief, again, was to make it as conservative as possible. It was more important that it passes than that it helps patients. And we had a lot of people involved in the movement disagreed with that, and myself very strongly disagreed with that. I saw what cannabis was doing for patients. My own wife was epileptic, and it immensely helped her. So I felt that the law had to help patients. The other difference is, they would say, well, if we put this in, the other side's going to say, what about the children? And I said, if you pass a statute that says people over 76 and under 78 can possess one joint in April, the other side's going to say, but what about the children? They're going to do that no matter what is in the initiative. Also, my feeling was very few people read the initiative. Maybe 5% reads the, if that much. Maybe 10% look at the voter pamphlet, but that at least 80% of the voters just walked into the voting booth and thought, I'm for cannabis, I'm against cannabis. And that's how they voted. And we could have gotten some much better initiatives, much better laws if we had written them to be good laws rather than just to pass by the highest percentage that they could. And there are other initiatives that were suggested that never got on the ballot because they never got the financing. And let's face it, you need financing to get these things on the ballot. The last initiative in California that made it on the ballot with just volunteer signatures was the Amorpha cannabis legalization. Back then it was marijuana legalization initiative in 1972. So it's been over 50 years since we've had an initiative get on the ballot without money behind it. And unfortunately, the people who had the money were also incredibly conservative. Sometimes I think they went to their lawyers and said, treat it like it's plutonium laced with arsenic. And so, that's the laws we're stuck with now.
Yep. Definitely still feel that way in many respects. I've got a final question as I'm asking this, if other people have questions, feel free to put it in the chat as we wrap this up at the top of the hour. But my question is this is just your perspective, Bill, as somebody who has had so much has been doing so much work for a while on this, and we have a lot of we have a lot of participants on our call who were farmers in the Prop 215 days, became legal, and are or continue to be legal, but legal under the newest framework of Prop 64, I should say. But as people are navigating this and are working as homestead farmers and small farmers, especially those legacy operators who have been there since the 215 days, what messages would you tell them about just hope and resilience and trying to continue to navigate.
Well, every once in a while, as I'm looking forward and thinking of what we should do, what changes should be made, etc., I always make sure to stop and look behind and look where we were and where we've come from. I mean, I am really happy that it has been years, several years, since I've had to worry about my client actually going to jail for cannabis. I mean, people are still getting busted. Some DAs are being creative, trying to still find ways to charge people with felonies. I have a case right now where they're claiming that she was transporting cannabis in the car. They found it, and they're trying to charge her with a felony for not paying the excise tax on it.
Wow.
Whether or not that applies to the situation is yet to be determined, but they're trying.
My goodness. Well, thank you so much, Bill, for joining us today and giving us the insight that you have with the, just so limited scope that we are all dealing with. And yeah, love to see some sort of expungement as was promised. Appreciate your insights and time, Mr. Panzer.
Um,
Uh, and that was a comment from
if
the
I could
chat.
comment on the expungement,
Please,
um,
please.
most past convictions can be expunged. Prop 64 did provide for some automatic expungement, though a lot of counties have ignored that and haven't done it. But I've expunged many convictions for cannabis over the last few years. It's not that difficult. It's not that expensive. I would strongly recommend anyone double check to see if your county already expunged it, and if not, get a lawyer, and you can even figure out how to do this yourself. It's not that difficult. But if you got a conviction on your record that you can get expunged, go ahead and do it.
Thank you for that, Bill. All right. Well, appreciate everybody's time. Thank you for joining us, Bill. So grateful that you are here in Nevada County. Aaron, do you have any closing thoughts? Or Bill, do you have any closing thoughts for us first?
I love Nevada County. I used to do a lot of cases up here, and always loved the area. And when we moved last year, we decided let's move up here, and glad to be up here. It's absolutely gorgeous, and it seems like the businesses, the two dispensaries, at least that I've visited in the Grass Valley and one in Nevada City, are thriving. It's a great site.
Great. All right. Aaron, do you have any closing thoughts for us?
Just one comment from Zach. You're the man, Bill. Thank you. Many blessings. Good health to you and yours, and stay in the fight. That's a great way to wrap up. And just to remind everyone, this webinar was recorded, and you can access it on our website at nccannabisalliance.org/getlegit. And that is it. Thank you so much again, Bill, for being here. We appreciate your insights and your wisdom. And we'll have to do a follow-up after that upcoming DEA hearing. So
Yeah.
maybe we can have another webinar to host.
Okay. Well, you're very welcome, and thank you for the work that you and your organization do. It's great work.
Thank you so much.
Thanks, Bill. Have a great one. Thanks, everyone, for
Take
joining
care,
us.
everyone. Have a good one. Bye.
All right. Bye.